Bismillahirrahmanirrahim. It is my pleasure to welcome you to a very special podcast that we are conducting today at the Research Society of International Law. Ladies and gentlemen, for many years we have been hearing about the rise of a multipolar global order. But today, this is no longer an academic concept anymore, and the reality of a multipolar world is now facing us directly. Because of this, we are seeing an intense resurgence of great power competitions, and the world's superpowers, both established and emerging, have been locked in a high stakes game of strategic influence, economic supremacy, and technological dominance. This landscape of competition, as one might expect, has had significant implications on the fabric of international law. And we are seeing battlegrounds emerging all over the world on key strategic issues and key areas such as trade, sanctions, access to technology, territorial sovereignty, and broader issues of emerging technologies and the rise of minilateralism as well. In Pakistan, for us as a middle power, it is very important for us to understand the legal positions. At RSIL, we do not engage in political partisanship. We do not believe in emotional rhetoric, but we try to understand the legal positions and try to understand the positions of state from a legal perspective. And for this reason, it is now our considered position that in order for Pakistan to evolve and engage in this new world, we must engage with all states and begin to understand their positions from their own viewpoint. And for this reason, now we are very pleased to be engaging with the Chinese position, which has become critical over the years. We have seen the Chinese really engage with international law and really try to attempt to shape the global order by effective and rigorous engagement with international law. I'm very pleased to have with me Professor Zhang Naigen. I hope I'm pronouncing that correctly, Professor.
Correct.
Professor Naigen is a university professor at Fudan University, a very old and established university in China, and he also leads he's also the director for the Center of International Law at the Fudan University Law School. Professor Naigen is also the vice president of the China Society of International Law and visiting Islamabad currently for the Islamabad Security Dialogue. We're very, very pleased to have you here, sir, at RSIL, and very excited to learn more about China, its experience with international law, and your views on how the role international law is playing in great power relations today. Welcome again.
Thank you very much. First, I appreciate your invitation come here with your society. And also, I appreciate the invitation of the Pakistan government for my attending the Islamabad Security Dialogue forums. And it's my first visit to Pakistan. And I hope in the future I will come here again.
Absolutely.
And talk with your colleague. And for the history of the international law in China is not longer, and because the international law originated in the Europe and then developed overseas, and I think older generation in the late Qing dynasty and early period of the Republic in 1920s. They went to the United States and UK to study international law, and then returned to China and teach in the Chinese university, including our university, in 1911. It's one of the earliest university of the public international in modern China.
Very interesting.
And actually, the Professor Wang Chonghui, he was the first JSD holder from the United States and became the high rank official for the Republic of China since the 1911.
Right.
So that's the beginning of international law in China. And after People's Republic of China was established in 1949, October 1st, And we continue our research in studying teacher international law in mainland. The political separation since then from the October 1st, 1949. And for China, I mean the People's Republic of China, and we pay more attention for the international law. Since the PRC was established, the foreign minister, the first foreign minister, Zhou Enlai, he was very famous and to initiative with the neighboring country to promote the bilateral relations and so-called peaceful coexistence, and for 5 principles, peaceful coexistence principles. That's become the international principle in regional and global. That means from very beginning of the PRC, we pay attention for international law. And for the teaching in university for historical reasons, began in late 1970s. When I went to the law school in 1979, I became the first class for international law study.
Really? Wow.
Yes, I have studied and research teaching international for more than 14 years. And after graduating from my mother law school, East China Institute of Politics and Law in 1983, I went to the Fudan and pursued my graduate degree and JSD, and then I became the law faculty in the Fudan since 1986.
Wow.
So the international law is the basic course for our law schools. Right. So that's for my personal career to study international law and to teach international law. And I think for general understanding Chinese government for international law, I just mentioned for peaceful coexistence actually follow the Charter of United Nations. But for historical reason, China returned to the United Nations. That means the legitimate seats for China, but only People's Republic of China since 1949, October 1st. In 1971. So half century passed, and for this reason, for United Nations at that time, China, I think, should be, because China was the founding member of the United Nations in 1945.
Yeah.
For political reasons, and China was not continued membership until 1971.
This brings me to an interesting point, which I wanted to talk from. That we see that even though, like you said, obviously in the roots of international law in China are as early as the early 1900s and then in the United Nations, but for the initial part of when the UN framework came about, we did not see China take a very active role for the first 25, 30 years.
Yeah.
And even in the 1970s, like you mentioned, these law schools started coming about. China's engagement was, slow and cautious.
Yeah.
And now around by the late 1990s, early 2000s, China seemed to have picked up pace along with its, I think it goes hand in hand when China's economic takeoff began.
Yeah.
We saw that its engagement with international institutions and international law generally changed. And now in 2023, another 22 decades later, we are seeing that it has reached a position where it now wants to actually contribute to how norms should be developed and play an active role in kind of reshaping the legal architecture. Is that a correct assessment? And
yes,
what are
you
the
are
factors
correct,
behind
because actually maybe we can take 3 phases after China returned to United Nations in 1971. 3 phases. First phase from the early 1970s to late 1970s, because due to the domestic political turmoil, as we say, and only 1979 we officially ended such a kind of domestic turmoils.
Right.
We say we open the door for foreigner and we take the domestic reform. So that's from the 1979. That's the year I went to the law school studying law and particular study international law.
Right.
So that's the first phase. At that phase period of time, China, I think, did not play very active role in the United Nations. I think only 1976, when the former senior leader, party leader Deng Xiaoping, went to the United Nations, addressed for the United Nations General Assembly. That's the only events in that time. And a second phase from the late 1970s, exactly 1979, change the policy, open door. Open door, we need the international law, generally,
Right.
not only for foreign minister, for generally. And in particular for the open door, and we hope more foreign investment come to China. And we need to know what is the rule for the business with the foreign company. So we need to know the international law generally, particularly for the economic law. So since then, going to the 2001, that's the second period because 2001 is a landmark for China accessing into the WTO,
WTO,
World Trade Organization, and change China and also change the world until now.
Right.
I think that second phase, China starting gradually to know what is the function for international law, not only for political reasons, but also mostly for the economical reasons. And we have the more institution and university, law school to offer the international course. In addition, my university, my mother law schools, and also for other law schools to teach talents of international law.
Right.
And also, China Society of International Law was established in 1982.
Right.
So it's my society. Since then, I'm the member. Even I was the students can participate the society annual conference, and so that's the second phase. China gradually to play more active, including China arrange the judge go to the International Court of Justice in 1986. First after China returned to the United Nations. So we appointed the judge because China is one of the permanent member of the Security Councils.
Yeah.
Usually should appoint the member candidate for vote of this General Assembly.
Right.
And since then, Chinese from the 1986, and we have the judge sitting in The Hague.
Right.
So that's the one side. We actively involved in the international law practice, and also we send some experts to the United Nations, and also specialized engines such as WIPO, World Intellectual Property organizations. And so that's the for second phase. And but since 2001, I think develops quickly. And the one reason is a World Trade Organization. Before that, China did not involve any third-party disputes settlement with Chinese government, ICJ or other ITLOS, International Tribunal for Law of Sea. But China accession into WTO is a compulsory jurisdictions.
Yeah.
And for the trade disputes, we had to go to the Geneva to settle disputes with other members, including the United States, European Union, and other members. So also China take active initiative case against the United States particularly. So we need legal experts. For example, I was the legal expert not only for public intent but also trade law.
Right.
I was the first listed as the panelist for trade disputes for WTO.
Interesting.
And then we training more experts for the trade law, and then we learn more from the existing member United States. Actually, we invite the United States and the European Union attorney come to Beijing to offer the course.
Really, this is fascinating, sir, because
Yeah.
I really want to kind of dig deeper into this, because for Pakistan, and especially one of the core purpose of our society is to develop capacity in international law, in technical areas of international law in Pakistan, because we feel that Pakistan's state practice and positions on key issues will be better informed if you have domestic expertise on
Yeah.
issues. And it also helps you now in this multipolar world to predict what is going to happen,
Yeah.
rather than just reacting like we seem to always do. So RSIL over the past 30 years, a core focus of our work has been on capacity building, developing courses, teaching people. And now, but it's been a challenge, because trying to make people, in the first decade of our evolution, we were trying to explain to people why international law is even important. People thought that it's not even important, it's just something which big countries do, and it doesn't, for small countries, there's no space for international law, so why bother? That thinking over time has changed. We've played a major
Yes.
role in that. Now people in Pakistan, policymakers, stakeholders, understand the importance of international law, but we don't know how to develop that specialist capacity. So by using, when it comes to China, I'm really fascinated to know that how does a country which 50 years ago did not even engage with these mechanisms, how has it reached a point where it not only, with the WTO being a prime example, not only has it acceded to the WTO just 20 years ago, but
Yeah.
now is leading it, and it's how did it develop so many domestic experts in WTO law? Was it because your universities are structured in this way? Was there political will from government at the highest level which pushed it? And how did you get experience of international systems, like, beyond China?
I think refer to the trade law. Trade law, I think, is based on the international general, because WTO is a trade-based, rule-based mechanism. So we take the national level and the provincial level and the school levels, university levels, 3 levels. For the national level, we established the National Society of WTO Law.
Right.
I'm also vice president
Right.
of the society since 2001. Before China accessed into WTO, we prepare
Right.
because we need talents, experts for WTO rules.
Right.
And we have society, we have annual conference, and then we have the many symposium and program
Right.
and publications. So that's the national efforts that's supported by the state council.
Right.
And for the provincial levels, we encourage provincial, because we have 32 provincial. For example, Beijing, Shanghai, and also Xinjiang autonomy. That's the second level, like the states or federal countries.
Right.
So establish the provincial society to study international. For example, Shanghai, I'm the founding chairman of the Shanghai Society of the WTO Law.
Right.
We enrolled the member locally, university, institution, company, government official, judge, if they are willing to join our society. We have annual conference, and also we have many symposiums, discuss the case, and submit some suggestions for the national government, in particular for MOFCOM, that means the administration commerce, which is charge of the WTO affair. So that's the provincial levels. And for provincial level, we have the university-based support. For example, Fudan University gave us many support financially, and also the office And also for the university, for many school and universities, establish WTO institution
Wow.
and offer the course and also offer the LM or PhD programs
Right.
since 2001.
Right.
So that's the three levels. And then because China is a larger country, we have the huge populations.
Yeah.
And so we need to educate them not only for WTO case, but also for business after graduation, go to the company. They know the anti-dumping and the subsidiary countermeasure and for these trade remedy and also for other WTO rules. That's for them to working.
Right.
I think since then we have trained many talents nationwide for business.
Right. That's absolutely fascinating. I mean, just to know that you have such a detailed, multi-tiered structure
Yes.
domestically that is, been able to train such a large number of lawyers and experts, not just on the international, like you mentioned, but also on domestic regulation as well. I want to discuss some, specific issues of international trade law as well. We know that the U.S. and China is, there's been a lot of cases. There's been a lot of disagreement on different issues. And for China, it has been that for getting market economy status. But China feels that 15 years after its accession, it should automatically have been granted market economy status, and that is not, we're seeing for different reasons the Western countries are not willing to offer that yet to China. Apart from that, the US argues that China has forced technology transfers. That it's the role of state-owned enterprises is disproportionately large, but increasingly, because of all these factors, the dispute settlement processes also we perhaps see China gaining the ascendancy in dispute settlement mechanisms, and there seems to be, I don't know, my sense is that Western countries seem to be stepping back from dispute settlement processes as China's ascendancy has increased. So I don't know whether that is a correct assessment in my view or not. And how do you see these criticisms on China's, transparency or regulation internally? How does China respond to these criticisms?
I think first I need to clarify the legal issues regarding to the market economy, non-market economy, and also the forced transfer technology for these two legal issues. And first, I would say that since China accessed into WTO, China has changed 1,000 domestic law regulations because we need to comply with WTO rule.
Right.
And the rule, actually the treaty, if you access into WTO, you have the obligation to implement it domestically.
Right.
That's why we change many domestic laws.
Right.
But for WTO rules, does not say anything about the non-market economy. If we read 100 pages, 1,000 pages, the legal text of WTO rules,
right,
does not say anything non-market economy.
Right.
And only the wording appear in the China protocol accession to WTO 2001.
Right.
That's the Article 15.
Okay.
And so that's the facts. It's legal facts. If we read the legal text, WTO existing unilateral on the negotiation single package and the China protocol for accession to WTO. So that's the legal issues. We need to take the legal test as legal basis.
Yes.
And but why the case arising after expiring of the we say the transactional period from 2001 to 2016, the case arising. between China and the EU and also with the United States. The case went to the panel proceedings, and I'm the legal advisor for MOFCOM, China Ministry of the Commerce.
Right.
The issue is that the article China accession into WTO only says that if China accession into WTO, under the general rule of the WTO already have, that means the anti-dumping agreement as the part of Uruguay round negotiation results, for the margin of anti-dumping depends on the export goods price and import into the destination countries importing. So you can take the margins. That's exactly price. So that's based on the market, yes. General Agreement on Tariff and Trade, GATT, we say, in 1948. And the 1995 WTO still based on the GATT. For this mechanism is based on market economy. That's true. That's true. And but for China protocol, which says that because China want to take a domestic reform to change it somehow, in particular for the stand-alone enterprise, how to operate in the market. Generally, China want to separate the ownership and the operation. That means the ownership become the states.
Right.
That's the state-owned enterprises. No change, even now. But the operation should be marketing. That means the company should go to market. You can decide what you want to produce and what you to sell, go to abroad. That's absolutely the market orientations. So that's separation, ownership, and operations.
Right.
And for our understanding, WTO allowed ownership because the protocol does not say China must change ownership.
Right.
No. Only say you should operate in market. If it does not operate in market condition, the import country, EU country or United States may take the condition, non-market condition, for particular case, not for the country as a whole.
Okay. Okay.
So the case arising, the EU and the United States want to take the case trade China as a whole. And that means for particular products, if export from China go to the United States or European Union, no difference impose the discriminated anti-dumping duty. That's violation of the WTO rule, including Chinese protocol accession into WTO. That disputes. And I think finally disputes has not been finally issued a panel report by the negotiation between China and the European Union, because first case, and the United States did not initiate the second case following EU.
Right.
So it seems to me the case has been settled.
Right.
Settled. So that first case. And for the second case, forced transfer technology, United States initial case, EU want to follow, but in fact, the case did not go to even the panel proceedings.
Right.
Stop.
Right. So this seems to be more, you're saying, of a political position, but in the legal, in the dispute resolution mechanisms, we're not seeing it play out to the extent that it dominates the political.
Yes, I think it's the political issues, not the legal issues, actually.
Right.
For legal issues, you need to read the legal test. What's the legal basis? So actually, United States, European Union had the disputes with Chinese government. You need to go to the negotiation table.
Yeah.
It's a negotiation to settle some misunderstanding. Maybe you misunderstood or you misunderstood, whatever. You need to talking.
Yeah. But this question of negotiation brings me to a related question about the general Doha round as well. I mean, the Doha round has been stuck now for 20 years, and it seems that the differences between the developed and developing countries, seem to be actually widening. And to the point that when we read these articles, I don't know if that is the case in practice, but at least certainly academic articles seem to indicate that the stalling of the Doha round shows that multilateralism generally is declining, and countries are moving away from WTO type mechanisms to smaller groupings, which can be much better and faster. That I think is a bit simplistic, because the WTO is a very structured and a very major process. It cannot just be sidelined by these small regional groupings. We should not have the kind of dispute settlement mechanism or the global authority which something like the WTO has. But do you think that this basic concern is correct, and the fact that we are deadlocked in the Doha round, does that augur poorly for the WTO in general? And since China is clearly benefiting from having a rules-based WTO order, is China worried about the slow pace of negotiations?
I think maybe we can take this issue from two respects. First, respect for the agenda of development, that's Doha Round, initiated in the 2001, exactly same year for China access into WTO, and agenda for developing countries. Because the Iraqi Round negotiation initiated by the developed country and developing country, including the Pakistan, the India, the South Africa, Latin American country, concerning the tariff issues and market exemptions. Not a favor, even they are the principle we call it differentiation regarding to developing and least developed country, but not enough. So that's the agenda for development. And it's a comprehensive package mandate for the negotiation. Originally should be ended 2005, July 2005, because that deadline depends on the United States Congress authorized the negotiation power for the president to negotiation for trade issues. But unfortunately, due to the 9/11 events, the United States initiated two wars, in particular 2003, the war against Iraq, Saddam Hussein. So it seemed to the international community, the United States Congress did not pay more attention for the trade issue, for the anti-terrorist, and did not extend the authorization for negotiations. Even partially until 2007, that's the 2005 Hong Kong military conference decided to close the negotiation as soon as possible, because the Congress gave a very short extension for the negotiation. But the 2006 finally declared failed to get a consensus for conclusion of negotiation comprehensive. So that's the first phase for the Doha Round development. I think developing country and the least developed country are disappointed.
Yes.
And then go to the next issue for the dispute settlement mechanism, because now WTO settlement mechanism seem to me paralyzed.
Yes, absolutely.
Many cases pending for review, but no one knows when will be reviewed. So that's from the 2007. 2017. 17, not 2007. 2017, the Trump administration went to the White House and changed the policy. We say unilateral policy, not only for trade war between China and the United States, initiated unilaterally imposed the 25% duty on all the Chinese goods go to the United States. That's the violation of most favored nation treatment. That's a basic rule for the WTO. And also, the United States accused the appeal body violated the understanding dispute settlement at DSU. But the majority member do not agree with the United States accusation. And so,
But it still caused this paralyzation of the dispute settlement system by the US taking a step back from it or not engaging with it.
yes, because the United States was unsatisfied for three basic legal issues. One is not for China, zero in, for the anti-dumping, because there were 16 cases against the United States. First, the European Union, and Japan, Tokyo, and finally maybe China.
Yeah.
So the ruling made by the appeal body consistently ruling that the United States violated WTO law,
Right.
anti-dumping rules.
Right.
But the United States is strongly against appeal body rulings. So that's the one issues generally.
Right.
And then the two another issues particularly target China. One is for the public body. That's for the subsidiary and anti countermeasure
Right.
agreement.
Right.
United States accused appeal body make the mistakes to interpret the subsidiary countermeasure agreement for public body. So, but it's a purely legal issues, interpretation of treaties. And the third is the non-market economy. That's the I just mentioned
Yeah.
related to the China protocols and into WTO. So for these legal issues, for my personal observation, it should be based on the legal test. And if the existing law, you say want to change, you need to negotiation
Yeah.
with the other WTO member, not unilaterally say you must change it, because that's the multilateral mechanism.
Right.
WTO has the 164 members, and traditionally should make a decision that means the positive consensus. Any member has power to veto.
Yeah.
United States and a small country is equal.
Yeah.
That's the existing law made by the United States already
Exactly.
during the gap period 1948 to 1995. Not made by developing country or least by the United States.
Yeah.
Now they want to change the rules.
So this is very interesting because I mean this period that you're talking about, I think it started it came out in the open in the Trump era when Donald Trump was president, when he and the US before that used to be known as being very kind of subtle in its diplomatic engagements and relying on international law and diplomacy to kind of get its objectives. But Donald Trump came out and said things very clearly that China is a threat and they're doing this, and the WTO and all these bodies are actually harming US interests, and that's why took a step back from it. Whereas now we're seeing China is using, like you said, relying on the law, legal procedures and treaties, and it seems to be a reversal of position. But the US is still its power is cannot be denied, and the fact that it is disengaging from the WTO in the manner that you described, do you think that has a dangerous repercussion on how effective that, like, is there a concern that the WTO itself might become dysfunctional because of these developments, and what is China doing to counter that?
Yes, that's the big questions and also challenge faced by the international community.
Yeah.
And because last July 12 conference, ministerial conference with the 12C in Geneva decided to take the new agenda reform of WTO.
Right.
Because WTO was established in 1995 and virtually 3 decades ago, and now member become more and more, and also technology development and the world change. So WTO law must be changed somehow. So it depends on negotiation.
Yeah.
Seems to me last year the military conference decided to follow the Doha partially agenda to negotiation for the reform of WTO.
Right.
The United States did agree to make efforts to promote the reform of WTO
Right.
Since last July. But the critical issues, shall we take the appeal body so-called with two-tie dispute mechanism, or become the one-tie only for panel, no appeal body review.
Right.
If take the one-tie, not a two-tie, means fundamental change in existing law.
Right.
Majority member do not agree with the United States proposal, and the
Right.
United States submitted the, I think not publicly disclosed, but I was told that in the Geneva, our mission take the closed door negotiation. China does not agree with the United States to totally change the existing law.
Right.
So that's the critical issues. Seem to me that seem to international community, should the United States change the law fundamentally? For what reason? For the reason I just mentioned, three legal issues. If for three legal issues, let the legal experts to change it, to interpret it again, not by the government simply a statement to say you must change it.
Right.
So it's not appropriate, reasonable. So we hope negotiation find a way, compromises, and to promote the multilateral based WTO systems, not fundamentally change it, but improve. For example, limits the appeal body interpretation, whatever. You should revise the rules, but not change the rule fundamentally.
Right.
So
Right.
we are looking forward very much for next year, because next year the next military conference held, whether they can resolve these disputes between the United States and majority member, including European Union,
Interesting.
Japan. So that's the critical issues.
Professor, I can go, talk with you for much longer on trade, since, you have such access to such a wealth of information. But there's so many other topics to also discuss.
Yes,
So
of
I'm
course.
also so the second kind of big picture issue, which we are increasingly following closely, again from a legal perspective, is obviously China's position on the law of the sea, and its application in the South China Sea. Now, in Pakistan, not many people know the intricacies of this particular dispute, but the general perception that a layperson gets, non-technical, but just the person who's broadly interested, is that China has taken a very a unique and also quite an aggressive interpretation of UNCLOS, how it applies to territorial sovereignty, with regards to the territory, and also with the exclusive economic zones. The examples of Chinese state practice of land reclamation, islands construction, military construction as well. And now increasingly we are seeing maritime enforcement actions. Domestic laws have been passed which have allowed the Coast Guard and maritime militia to enforce these laws. But alongside this, we are now seeing the US and other countries. First of all, a lot of other countries seem to be in the region, Vietnam, Philippines, Malaysia, they seem to be, pushing against the Chinese position. You had obviously the landmark, UNCLOS tribunal decision involving the Philippines and China in 2013. That was quite closely watched by observers here. And now you have, the US engaging in freedom of navigation operations in the South China Sea. And all of this seems that, we watch with a lot of tension, because it seems that this is heading towards a military confrontation as well, and there are so many things at stake. Not only there are territorial claims, but then there is also access to natural resources, and and then the maritime navigation routes, and the increasing role of India in this whole equation. So it seems to be something which I think Professor Bruno Sima also today at the Islamabad Security Dialogue mentioned, that the main geopolitical and the main factors are now moving from the West to the Indo-Pacific, and this seems to be at the center of it.
Yes.
And international law is such. So, I just want to get an understanding of China's position. It is the Americans. When I read their article, their journals, they talk about how China is using lawfare, to aggressively push for a certain interpretation of international law. And this is something which, if the Chinese are doing this, they have learned this by the Western playbook, because the West also used to take a position, political, and then supplant it with, aggressive legal, arguments, research, and, pushing through. So it's not something which is new. And it seems, but it's interesting for us because China is relying, even what we see with regards to the 2013 Philippines decision, that China came out with consistent policy positions after this as well, which kind of challenged the legitimacy of the award or tried to give a new interpretation of it. In fact, an interesting example, like when the decision came out, RSIL, we developed a basic brief on our website on this decision and what it says. It was just a simple brief. And I see, because I get the website statistics every month for our communications team, that article from 10 years ago is still downloaded hundreds and sometimes thousands of times from China. So that means does that mean that China has also, like you mentioned in WTO, developed a lot of indigenous capacity on the law of the sea by having a lot of domestic expertise? How is your engagement evolving with UNCLOS?
Thank you for your question on the law of sea. I think China Society of International Law published the reply for the Tribunal Award in 2016. We published our reply entitled the critic.
A critique, yes,
comments,
I'm aware of that. Yes,
published by the Oxford University Press, that's by the Chinese Journal of International Law in 2019. 500 pages.
Wow.
It's a similar with the award. We say you have 500 page award. We need to reply you page by page.
Right.
And I personally, because that's our society work, I'm the personally involved in these documents prepare.
Right.
And final checking out and sentence by sentence, words by words, English version.
So I'm talking to the right person then.
Yes. So it's hard work. And first I would say Chinese government take the long-stand position to settle disputes on territorial disputes and maritime boundaries. Before China ratified the United Nations Law of Sea Convention on UNCLOS, and China already settled territorial disputes with Myanmar and other neighboring country in 1990s with the Russia now. So only one territorial dispute unsettled with the India.
Right.
But we are looking forward very much for future peaceful settlement between China and India for the territorial disputes.
Right.
Because China has the position to settle territorial disputes and then extend to the maritime boundaries by negotiation, not by the third party adjudicate either court or arbitration tribunal. That's not only for law South China Sea. I just mentioned since 1915, the first settled territorial disputes with neighboring country. So
China
that's
takes a
the
bilateral
long-standing-
approach.
Long-standing. That means if we have disputes on territory, on maritime disputes, we should negotiate because the critical issues for any disputes on territory and maritime boundaries, you must go to the history.
Right.
Not a trade issue, maybe current business.
Right.
For territory, you need to consider the historical considerations, how to take both sides
Right.
from the historical perspectives. So we need to negotiations and take two sides. Also, we're neighboring countries. Neighboring, we live in neighboring cannot change.
Yeah. Yeah.
We need to peaceful settle disputes and forever. So that's the Chinese long-standing position and my understanding, not only for South China Sea.
Right.
That's the incessant positions.
Right. Right.
That's the first issues. We must understand what's Chinese position. Maybe for other countries, they say we should go to the International Court of Justice.
Yeah.
But a different country has different history and a different position. So we need to respect each country position for territory, maritime, boundary delimitations.
Right.
So I think that's general rule of
Right.
international law.
Right. That's interesting because coming to boundary disputes,
Yeah.
and you mentioned India as well. We saw that, and I have a couple of questions on this,
Yeah.
so I just want to kind of lay the ground for it first.
Yeah.
We do see that there has been a confrontation. India's actions, unilateral actions in Kashmir on 5th August 2019.
Yes.
Also involved, has implications for a third country, China, because
Yes.
of the line of actual control.
Yeah.
And we saw tensions spill up with the Ladakh border dispute. It's something which, a lot of people watch closely, but the legal aspects are often not understood.
Yeah.
China now, and last month, or I believe 2 months ago, has also actually begun to rename certain places in Arunachal Pradesh and argue that, these are traditionally part of Tibet. But the Indians are also building. Our assessment is that perhaps India took this action so that Ladakh issue with China could be separated from the larger question of Jammu and Kashmir. And so Jammu and Kashmir can become a Pak-India matter,
Yes.
and Ladakh can be a separate matter, like you mentioned, with China. That obviously is something which Pakistan does not agree with, because it was meant to be always a trilateral kind of an issue. And if India wants to take this approach, it has to be done through negotiation and mediation and agreement of all parties, rather than unilaterally as well. So I wanted your views on that. But beyond that, I've been reading President Xi's the different doctrines, and in that, the Global Security Initiative, the concept paper which the Chinese Foreign Ministry released, I believe it was 2 years ago. So there are some important words which I wanted to just highlight and get your take on it. First, which I feel can be very useful to Pakistan in its dispute resolution with its neighbors, which you cannot resolve. So first of all, it says that it stay committed to abiding by the purposes and principles of the UN Charter. The various confrontations and injustices in the world today did not occur because the purposes and principles of the UN Charter are outdated, but because they are not effectively maintained and implemented. That is an interesting point. Secondly, it says the legitimate and reasonable security concerns of all countries should be taken seriously and addressed properly, not persistently ignored or systematically challenged. That is also very interesting. Then it says, the point which you raised, staying committed to peacefully resolving differences and disputes between countries through dialogue and consultation, which is the point you just raised right now. And promote political settlement of international and regional hotspot issues. Encourage countries' concerns to overcome differences. Now, with regards to India-Pak relations, and especially the big question of Kashmir in Pakistan, when it comes to international law, that seems to be the only issue that matters to most Pakistanis. We are concerned in Pakistan because we relied on the UN Charter
Yeah.
and the UN Security Council resolutions, which established first and foremost that this is a dispute.
Yeah.
I'm not going to go into the contents of the Security Council, what was Pakistan supposed to do, what was India. It now seems quite clear 70 years later that the proposed formula which the Security Council had proposed in 1951, 52 is no longer practical today.
I
But
see.
Pakistan's point is that the issue is still an international dispute. The Security Council resolutions crystallize this.
Yeah.
Whereas India wants to make it, first it wanted to make it a bilateral issue, and
I
Pakistan,
see.
as a sovereign courtesy, said
I
it
see.
could.
Ah.
But we said that it doesn't, it still does not oblige us to comply
I
with that.
see.
And now the Indians are saying that this is an internal matter. It was never a dispute. It's an internal, integral part of India.
Yes.
Never something to be discussed. And the world community is also seems to be silent because of India's economic clout. I think that President Xi's doctrines on this is useful because it looks after smaller countries like Pakistan, which has to rely. We have to rely on rules to exist. It
Yeah,
cannot be that
understand.
now India is powerful economically, so it's inconvenient to criticize them or inconvenient. So do you see that these doctrines taking it benefits countries like this, but certain other countries will also be opposed to this approach? How do you think that this security initiative can play a role in, for example, bringing Pakistan, India to the table? Because Pakistan has been wanting to negotiate for decades now, and the Indian
see.
position is only getting harder and harder.
I see. Follow my explanation for Chinese long-standing position regarding to the territorial disputes, maritime boundary delimitation disputes, and a second issues, I think, case by case. First, you need to respect the each sovereign state's willing to settle disputes in what kind of approaches.
Right.
So that's the equality of the sovereign states. We need to mutually respect it. Not unilateral, but you need to mutually respect each other. So
Right.
that's the Charter of United Nations, Article 2,
Right.
Paragraph 1, and also Article 33 for the negotiation, peaceful settlement
Right.
disputes. That's
Right.
the general rule of the international law.
Right.
And the second, the case by case is very important because you mentioned the disputes between the India and the Pakistan after decolonizations. So that's the case. And also maybe we can see Ukraine crisis
Yeah.
and former Soviet Union and Ukraine and then Russia and
Palestine, and yes, of course.
Yes,
Yeah.
each case you must know the particular historical
Yeah.
background.
Yeah, of course.
And for my understanding, under the Charter of the United Nations, no matter large one, small one, sovereign states are equal.
Yeah.
Should
In
be
theory, yes.
Yes, mutual respected.
Yeah.
And then you need to negotiations
Yeah.
to settle disputes case by case.
Right.
Of course, if another party, for example, Philippines want to go to the tribunal, say that the UNCLOS provide a legal basis, China says no, because China make a reservation for the third party settle disputes, maritime delimitation, and also first you need to settle territory. That's the islands. South China Sea, many islands. That's not for maritime issue, for territory, land. So that means case by case you need to resolve the legal test.
Yeah.
For your case, India and Pakistan, I'm not an expert for this case,
Yeah.
but in fact, the Security Council at that time make a resolution. So that means you need to consider the legal basis. And for Ukraine, you need to go back the former Soviet Union, how to divide the republic boundaries, and then after fall down former Soviet Union, how did there to decide the independent territory after fall down the former Soviet Union. So you need to consider historical background and bilaterally for these parties.
Right.
So I think the case by case is very important.
Yeah.
And International Court of Justice does settle many dispute settlement maritime delimitations. But if you read the case, you may find some cases settled well, some case even ruling made. But the two parties, for example, 2012, Nicaragua and Colombia, they want to settle it, went to the ICJ, didn't make the ruling for the maritime delimitation, including the St. Andrews Island dispute settlements for land. But Colombia did not was not certified of rulings. And so I think even ICJ made the rulings, but some cases may not settled.
Yeah, so in this regard, do you think that China, under this global security initiative, will play a more active role in getting countries to sit on the table and negotiate? Because as we saw, a recent exciting example has been the Iran-Saudi Arabia detente as well. So do you see that, China playing a more active role and, in bringing this expertise of negotiation and consultation? And what do you think the opportunities and challenges are going to be in that?
Yes, I think China now is concerned to promote the global governance, including the peaceful settlement disputes, are very important for global governance. And in addition, International Court of Justice, ATLAS, or investment disputes, EXAD, or PCA, Permanent Court of Arbitration, for all these international global adjudicated already existed. But it seems to us that it's not enough.
Yeah.
So China recently proposed to have the new institution, so-called International Mediation Court.
Yes, this is something which is very interesting for us.
Very exciting.
Could you please explain what this would entail and what would be the scope of this international organization?
Up to date, I only know that Chinese government make a proposal to invite interesting countries to settle down and to negotiation what kind of rule should be held. That's a Chinese idea, common consultation.
Right.
And common interests. And then we can enjoy the results to settle disputes by mediations.
Is this scope limited to commercial disputes?
No, not for commercial.
Really?
It's a state to state because we already have the commercial ICC in the Paris and Switzerland. And also many international commercial arbitrations.
Very interesting.
But for this international mediation court, only for states to states mediation.
Very interesting.
That means it's a convention based.
Right.
That's China alone to make a proposal. Currently, 27 interesting states willing to participate in negotiation for drafting article for mediations.
Interesting.
That's the substantial process to make the rule.
That would be a very fascinating new development.
Yes, I think that's the way to offer the international community not only to court, but also go to the mediator, because mediator is more flexible.
Right.
And if two, like the Saudi Arabia and Iran, want to settle their historical disputes, religionally, geographically, whatever, they want China as a mediator, actually, in Beijing. China first talking with the Saudi Arabia, and then the Iran, and then they invited two countries to Beijing, and negotiation, triple parties. Actually, China is a mediator.
Yeah.
And hopefully they can settle their disputes bilaterally. but China as the mediator endorsed because not only for bilateral, because China as the mediator endorsed more bonding forces. So it seems to me that's the model for future operation of international mediator court. That means any two countries want to settle their disputes may invite some countries, China or Pakistan or South Africa, whatever they want to, invite the country as the mediator.
Interesting.
And then they promote the bilateral negotiation and finally get an agreement, not go to court.
This is a fantastic. I mean, I did not know that it was beyond commercial matters and actually in these issues.
Yeah.
It's something which I think in Pakistan we need to follow very closely and support our government in its efforts in
Yes,
negotiating this treaty, because this can be a foundational shift in how, you
Yeah.
know, especially in a time when the rules-based order is fracturing and
Yeah.
we're seeing deadlocks in the traditional dispute settlement bodies. This
Yeah.
can be a very interesting,
Yeah.
very exciting new possibility as well. Professor, you talked about global governance, and I'm cognizant of time as well. We've taken a lot, and there's so much more that I want to discuss. But when we talked about global governance, and we do see that China has really been active in promoting, what they call shadow institutions now as well. Like, an alternative institutions are developing, whether it is, the Asian Infrastructure Bank,
Yes.
Investment Bank, or the Shanghai Cooperation Organization. There is a lot of excitement about these bodies as well, but then there's also skepticism about how they will impact will it actually fracture and divide the global governance, or will it actually, in the long term, or are they as effective as the Western-led bodies as well? How do you see the main battlegrounds, the main issues of global governance when it comes to we're seeing artificial intelligence and emerging technologies become a key area. Development finance is now a major issue, and we are seeing a deadlock between the historic Paris Club of creditors and the rise of China as an independent, separate creditor, which is now causing a lot of issues because the Chinese model is focused on bilateral financing, infrastructure focus, non-interference, and debt for equity swaps. Whereas the Western states criticize it by saying that this is not sustainable, that there is no transparency, and actually, countries are becoming sovereign. So, I mean, this is just one example, but we are seeing these battlefields emerge.
Yes.
In different areas of global governance, there's a Chinese perspective, and then there's a Western attack on that perspective. And how do you see that playing out? How do you see these norms? Can norms and standards develop in this fractured environment? Especially on key areas like development finance, which for countries like Pakistan I believe there are now 27 countries which are under debt distress and 20 more which are on the watch list. So if countries start defaulting and the system is broken for development finance or general, how do you get out of that deadlock?
I think there are many deadlock for the global governance, and maybe we can say three areas. Priority is the political area for the United Nations.
Yeah.
Deadlock for extension of the number of the permanent member.
Security Council.
Change the veto systems. So deadlock for decades.
Yeah.
And also for the financial issues. And actually, I must say for the International Monetary Fund, because the rule provide the United States is a sole veto power, more than 15% of shareholder allow the United States decided alone veto. So for developing country want to change something, but it's a deadlock also. United States does not want to change it. And also for WTO, I just discussed with you for the appeal body, the deadlock, United States want to change it, but for other majority member do not want to change it.
Yeah.
So there are many
And
deadlock.
climate change, of course.
Yeah, climate change also.
Yeah.
There are many deadlock for the global governance.
Yeah. Cyberspace and security.
Yes, cyberspace. So many issues, but basically you can politically, economically, and also for human rights issues.
Yeah.
Because Human Rights Council was established in 2006. Now is 2023, and originally resolution by the World Summit want to the Council, Human Rights Council, become separated from the General Assembly, but still need a review. So that's deadlock also.
Yeah.
There are many deadlock.
And actually, beyond deadlock, we're seeing a weaponization of institutions as well.
Yeah.
You know, like Pakistan's experience with the Financial Action Task Force, you know, when we were grey listed. The FATF was it was not a treaty or a convention which Pakistan signed, but it was a task force which was able to completely force Pakistan to change whatever it required us to do. And that, I think, was, from an international law perspective, it was exciting also because it forced compliance in a way. Like if FATF is successful, these kind of bodies, you can have fast cooperation on things like climate change and other things because it is standards-based bodies.
Yeah.
But we saw that its processes were politicized by India and to a certain extent by the United States as well. And so in Pakistan, we felt like we were forced into something under the rubric of law, you know. And so that ultimately, I think, as an international law lawyer and as an academic, I don't think that weakens international law, because when it is seen as weaponization, as just from a purely strategic perspective, then ultimately the law does not develop to benefit humanity. It just develops to benefit strategic interests of different states. And I feel that, you know, that is something which should be resisted, so that there is common application of law and norms that are developed based on, you know, the actual challenges which humanity faces, rather than, you know, protecting the strategic interests of 1, 2, or a limited number of countries.
Yes, as my understanding, facing the challenge, or maybe we say it's deadlock for global governance, we need to consider what is the approach to settle disputes, actually, deadlock. So the approach is very important. Seems to me, China now proposed to the approaches, enemies I already mentioned, the so-called three common consultation, common benefits, and common enjoying the results. And if it is the multilateral issue like the United Nations as the international community, 193 members as the United Nations family. So you need to consider what's the common interest for the United Nations, all the members, what's their request. So you need to consultation.
Right.
Common consultations, that's multilateralism, or regional, maybe Asia or Latin America or Europe. You need to consider regional common interests, common benefits, or bilateral,
Right.
like China and the Philippines, or China with other countries. So I think you need to consider approach and to consider what is the issue. Is a multilateral issue, or regional issue, or bilateral issues, and take the different platform to talking, to negotiations. As we say, global governance first should be peaceful coexistence and mutual respect on the Charter of the United Nations. I think a general rule and a general principle we cannot change it fundamentally. Otherwise, not international law.
Exactly.
So also we need a patience, because for some disputes deadlock, maybe long time got this deadlock. You need time to patient to settle disputes.
Right. Right.
So that depends case by case.
Case by case. Absolutely.
China, as my understanding, pay attention to settle disputes, return to our case South China Sea, because it's a very complicated issues with many nations, Vietnam, Philippines, Malaysia, even for
Brunei
other
and others as
countries.
well, yeah.
And so it's very complicated issues, but we need to pay attention, control the situations, and not get wars. And we need to encourage negotiations bilaterally or regionally. Actually, we promote the regional solutions for South China Sea neighboring countries. So I think the global governance need new approaches to settle disputes, gather deadlock solutions. Depends on I just mentioned the different areas. So because international law for last 400 years since beginning in the Europe continents developed nowadays 400 years. Return to the beginning, we are talking the international law, and I fully believe that international law did play crucial functions for global governance from very beginning, the European and then the global, and also for future.
Absolutely.
So I'm a lawyer, we're a lawyer. We fully trust that the law should be justice and fair. Of course, we need to make the law justice and fair. And then going to back the global governance, how to make the rule. I just mentioned if China proposed to the new institution, international mediation court, we invited the interested party, now is 27, maybe more, like the Asia Infiltration Banking, Investment Banking, BIIA, and actually AIIB. Actually now is 106 members, not only for Asia, except the United States, France, UK, Russia, China, 4 permanent members around the world become the Asia Infiltration Investment Bank. So I think you need time, let people to know that's the benefits for them. Then we come down to discuss the rule and for future global governance.
Excellent, Professor. That was really, really refreshing to hear your Chinese perspectives. I think the takeaway from what I can understand is that, even though we are in this era of uncertainty, but there is also simultaneously a lot of hope, and because there's so much opportunity as well. There's a lot of opportunities. I think the successful countries and the successful societies will be the one who develop indigenous deep technical capacity in these issues so that they are able to engage with these issues as they arise, safeguard their interests as well, while also contributing to, like you said, norms which are fair and just and which will ultimately ensure durability. So we're going through a difficult time, but I think these things, these discussions, these interactions are very important. I think Pakistan needs to learn from the Chinese experience of developing.
We learn each other.
We learn, but of course, how you have structured your internal capacities, your systems of promoting international lawyers. That is something which I think we would love to learn more about. And like you said, we can share our perspectives on international law so that the Chinese are more aware of Pakistan's historical positions and our concerns. So I thank you for your time.
It's my pleasure.
And we hope to carry on this engagement with Fudan University and with you as well. And with the Chinese society. Thank you once again, Professor. Thank you.
Thank you very much.